In DoorDash, Uber Eats news, New York City has passed a minimum wage law for those workers. Uber and other similar sites, of course, consider those people to be contractors rather than employees. But New York City is over here like, we don't really care what you consider them. We want you to pay them a minimum wage, no matter what. So they get a minimum guaranteed salary. And they're like, Uber's over here like, no, you can't do that, fam, because they're not employees, they're independent contractors. So no minimum wage. So this fight, which we have seen in California as well, unsurprisingly, also trending towards the Big Apple. Are these workers? Are they independent contractors? Can we regulate a minimum wage or working conditions for them? Let's learn a little bit more about this. Uber, DoorDash, and other app-based food delivery companies have filed a lawsuit on Thursday seeking to strike down New York City's law that would set a minimum wage for delivery workers, which appears to be one of the few that has actually tried to do this in this particular way. And so this particular version of this is a somewhat novel version of it compared to other states which have tried to regulate it in more traditional ways by saying that they're employees, for example. New York's method is novel. So that raises some interesting questions and also, of course, raises interesting lawsuits. The companies have filed separate complaints in New York State court claiming the law, which is to take effect on July the 12th, is based on a misunderstanding of how the food delivery industry works. Yeah, I'm not sure if it's based on misunderstanding or not, but okay. The law would require these companies to pay delivery workers a minimum wage of $17.96 an hour, which would rise to $20 an hour in April 2025. So, that's a pretty significant, amount of money that Uber Eats, DoorDash, etc. would be required to pay their workers. That is a notable rate of pay for these workers. Is not necessarily dependent on how many deliveries they do. It is just dependent on time. So that is a new way of regulating it. Rather than we'll give you a cut of what you deliver as part of our end, we have to give you a minimum. So that's an interesting way to go about it. Delivery apps would need to increase the number of trips completed per hour to absorb the new labor costs, which would force them to shrink service areas and harm consumers in restaurants, the company said. That is quite possibly true. New York City and a lot of other places don't necessarily think these things all the way through. So it's like, if you did this, it would cause us to have to deliver to a smaller area because we need to do more trips, right? Right now, we're delivering to a wider geographic area. More distance means more time because it takes longer to get further, right? So right now, we deliver to a wider area because we can afford to do it and we want to increase our customer base as much as we can because, that's good. Let's get as many customers as we can. So we have increased our geographic area as wide as we can, as you would expect within our current economics. So if you change the economics on us in this, what we'd have to do is radically shrink the delivery area because then less distance means less time, which means that we can do more deliveries because we have more time now. But we would have to also pass on those costs to the consumer. So it would increase the cost of the consumer and decrease the quality of that service. So, yeah, but sometimes these laws go into effect and they don't necessarily think things all the way through. They're just like, ooh, shiny company, pay more. And companies like, if you did that, it would lead to all these consequences, but they don't seem to think that's a problem for some reason. Uber and DoorDash both raised annual forecasts after beating quarterly revenue, stemming from increase in orders for food, groceries, and convenience products. Relay Delivery also filed a lawsuit in the courts, claiming the law would put New York-based company out of business unless it raises fees to charge restaurants. So as you would expect, in a city like New York City, which is very dense and very highly populated, but also has a lot of traffic, there is a lot of competitors for local markets, right? So Uber and DoorDash are nationwide, but some companies are more just specific for a city or a specific region, which in a place like New York City, you can do. So this company, which is New York based, is like, we're going to have problems with the restaurant delivery. We can't afford to do this. So we're going to have to increase the amount we charge the restaurants. They're going to have to increase the amount they charge the consumer. Prices will go up. This will be a problem. The head of the city's Department of Consumer and Workplace Protection said the law will help lift thousands of workers out of poverty. I'm not sure that's necessarily true because there may be fewer workers, because we'll have to service less people in a smaller area. So we may not, and also we have to pay them more. So we may not have as many workers. It's like DoorDash. Let's say DoorDash currently has 10,000 employees. That number I'm pulling out of absolutely nowhere. It's just a number for the sake of the argument. Let's say DoorDash has 10,000 employees. New York City's over here like saying, ooh, we can get these 10,000 employees more money, not realizing that those 10,000 employees may not necessarily continue to be employed. The minimum wage makes things more expensive. And when you make things more expensive, you tend to buy less of them. It's simple supply and demand, right? When the cost increases, demand has a tendency of decreasing because you can afford less. Delivery workers, like all workers, deserve a fair pay for their labor, and we're disappointed that Uber, DoorDash, Grubhub, and Relay disagree, New York City said in a statement. Well, are they being paired? Well, that it goes to the question of what is a fair pay. What is fair? That's a very loaded word. You want a 4-letter word that's loaded? Fair is definitely one. What is fair? Right? Because right now they're being paid based on the amount that's being delivered. They're being paid basically a cut of the proceeds. And now it's like we're going to pay you a minimum wage. Is that fair? How do we define fair? Fair is hard. Supporters of the law, which say it's the first of the kind in the United States, which I tend to agree it is based on the way they're trying to do this, says it's needed because delivery workers in the city earn about $11 an area average after expenses, which is below the city's $15 an hour minimum wage. Now, $11 an hour on average after expenses, because they're independent contractor, those expenses are tax writable. Those are writable off on your taxes. So how much is the before it? Because since you can write it off on your taxes, you have to like readjust that, because not all that, because some of that is get backable from your taxes because they're business expenses now because you're an independent contractor. So yeah. App-based workers are usually treated as independent contractors rather than company employees, so general wage laws typically do not apply. Correct. The minimum wage typically applies to employees. These are not employees. This is the thing, right? So other places that have tried to do this, like California, for example, have tried to do this by saying, well, these are employees. We're going to change their classification status to employees, which California might be very well able to do. Whether or not you're a contractor or an independent employee is very complicated, not for the least of reasons that there's multiple different definitions by multiple different agencies at multiple different levels. The federal government has one definition, states have definitions, localities have definitions, and even within like levels of government, for example, the federal government, there's different definitions. So the Department of Labor has one definition, Department of Justice has a different definition. Trying to find the line between these two things is not very easy. If you want the quick and dirty definition of the difference, we can look to several factors that sort of delineate this. Common factors that are often used as we're trying to determine whether someone's an independent contractor or an employee include, but are not necessarily limited to such things as, is this person using their own tools? So do they get the tools they need to do the job from the employer, or do they provide them? Do they set their own hours? Does the employer say you work 9 to 5, or does the person say I work when I want to work? Do they have the ability to work for other people or as an exclusive arrangement? Who sets the conditions of how the work is to be done and the method of how it's to be done, and so forth and so on? So these are some of the factors we look at. And when you apply these traditional factors to something like Uber, it does look more like an independent contractor. The people use their own tools, namely they use their own car, they set their own hours, they get to choose whether or not to work and when at any time. They can go online anytime they want, offline anytime they want. They can work for rivals. In the past, that hasn't necessarily been true, but I don't think that's true of any company today because exclusivity was one of the factors. And so they're like, okay, we'll take that away as a factor. So typically now you can work for multiple different companies at the same time if you want, and so forth and so on. So it does look more like an independent contractor. Now, the ability of a state to redefine that as a matter of state law may very well be possible. But New York is doing this a little bit differently. They're not redefining what's an employee and not. They are not apparently disagreeing that they're independent contractors. They're trying to apply the minimum wage to independent contractors, which doesn't really or hasn't really been done in the past. That's a novel way of going about it. So should be interesting. How does that work exactly is unclear to my legal mind. So trying new things over here in New York City, I guess. The companies in the lawsuits say that city officials justify the law based on flawed studies and statistics, which if that's their only complaints, that doesn't work. That doesn't work. Like, oh, they misunderstood the facts. No, that because it's a question of who gets to decide, right? So if they have the ability to adjudicate it, the fact that they misunderstood the facts is a little bit like complaining that a jury misunderstood the facts. Good effing luck, right? Good effing luck. Oh, they misunderstood the facts. They didn't understand the evidence. Yeah, if they get the ability to decide, though, that's kind of that. The question is what they decided legal, right? Is what they decide legal? Can they do that? So if your complaint is they misunderstood the stats, I don't really see that working. The city surveys of delivery workers were biased and designed to elicit responses that would justify the minimum wage. Yeah, well, whatever. I'm not necessarily sure that the city requires any sort of particular evidence. That's the thing, right? If the legislature can legislate, the legislature can legislate. So does the legislature need any particular evidence to pass any particular law? Not really. That they might go out and get evidence. They might have hearings. They might look for information. But on a fundamental level, is it required? Nope. Congress can legislate in the dark if they so want to. It's like we think there's a problem. Are we going to go look for any information that confirms whether that problem is real or not? No, we're not. We just believe it's a problem and we're going to declare it to be a problem based on our collective perception of the problem with no available information because we don't want to. Well, if that's what Congress wants to do, Congress can do it. Go show me the provision in the Constitution that says that Congress needs to get information first. Show me that provision. Doesn't exist. If Congress does go get information, can you complain that Congress's information was flawed or that they only wanted to hear from certain kinds of witness? They only wanted to hear from witnesses that confirmed their pre-held biases. So Congress believes the thing to be true, and they then only ask witnesses who will tell them what they already want to hear. Hey, that's not fair. Congress didn't hear from all the people. They only heard from their selected biased few. And I'm over here as a court like, what do you want me to do about it? Not much. So if the complaint is, oh, they went out and got responses that would confirm what they already believed to be true and didn't look at the whole picture, I'm not sure I can be bothered to care. The question is more, to my mind, can New York City fundamentally do this? Can they do it? I don't know the answer to that question. My intuition, based on my legal knowledge, is probably not. I don't think they can. I certainly want to learn more as a adjudicator on such a thing. But they got biased information, though, I can't be bothered to care. So tell someone else about it. I don't care. The lawsuits also claim the law is based on unsupported assumptions that restaurants make little profit from the orders and imposing burden record-keeping requirements. This fatally flawed and subjective rulemaking process unsurprisingly worsens these already problematic policies. Okay. Good luck with that, I guess. The companies accuse the city of violating state law, barring rules that are arbitrary and capricious. Well, fair enough. The government cannot act arbitrarily and capriciously. That's true. But arbitrary and capricious is a pretty hard standard to pull, right? Arbitrary and capricious. As long as the government has any reason that makes any sense, like on the most basic level, then it's probably going to be fine. Arbitrary and capricious is throwing darts at a dartboard. Arbitrary and capricious is no rhyme or reason, no rationale at all, not a flawed rationale. right? So arbitrary and capricious is pretty hard. I've definitely seen it happen, but it's a tough standard to pull. The government gets to make decisions. Those decisions don't always have to be wise. They are seeking orders blocking the law from taking effect while the lawsuits proceed, which I don't know whether they'll get the injunction or not. Maybe. We'll see. And that's all that's progressing. Thus, that brings us to the end of the case of Uber and Doordash suing New York City over New York City's somewhat novel attempt to resolve this tension between are you a contractor or are you an employee? Other places that have tried to deal with this have done it by redefining what employees are as a matter of law, which, when you're talking about the legislature, they can probably do. States and federal governments often have different definitions, and incidentally, you can be one or the other. You can be different ones for different purposes. So you, the person doing the job, you might simultaneously be an independent contractor and an employee. This isn't necessarily an either or proposition. It depends who's asking, right? So if the federal government is asking the question for the purposes of you filing your federal taxes, is the state asking the question for the purpose of answering your state taxes? Is the locality answering the question for the purpose of your local taxes? You may have to change the answer. So you may have to file different forms with different levels of government depending on exactly where you are between the two, which is annoying, but it's the law. So can a state redefine it in a way that conflicts with the federal government? Typically, yes, they can. Because typically there is no conflict with the federal government, because typically they're each doing it for their own limited purposes, not general purposes. So can a state do this by legislation? Probably. Can a city do it by legislation? I don't know. What does the city have the power to do? Can they do it by regulation? I don't know. Can they do it, in this case, not by redefining who's an employee, but saying, yes, you are an independent contractor, but minimum wage, though? I'm doubtful that's possible, but I'd want to know more. So it'll be interesting to see how this lawsuit progresses. And that, for the moment, brings us to the end of discussion of this case.